Welcome to SOS Media, your number one source of the latest news, opinions, and in-depth investigations that dig deeper into today's developing stories around the globe. Limitation-related constitutional challenges arise most often under the Constitution's ex post facto and due process clauses. The federal courts have long held that a statute of limitations may be enlarged retroactively as long as the previously applicable period of limitation has not expired. The Supreme Court recently confirmed that view. The ex post facto prohibition precludes legislative revival of an expired period of limitation. Due process condemns pre-indictment delays even when permitted by the statute of limitations if the prosecution wrongfully caused the delay and the accused defense suffered actual, substantial harm as a consequence. Retroactivity aside, the due process clauses may be implicated when a crime has no statute of limitations or when the period of limitation has not run. Although statutes of limitation alone generally govern the extent of permissible pre-indictment delay, extraordinary circumstances may trigger due process implications. Now let's familiarize ourselves with BONJEAN's school of thought as far as this statute is concerned. The statute of limitations is the time limit for filing charges against the defendant. The general federal statute of limitations for crime stands for the proposition that the government can no longer file criminal charges for an offense once 5 years has passed. This statute states that except as otherwise expressly provided by law, no person shall be prosecuted, tried, or punished for any offense not capital unless the indictment is found or the information is instituted within 5 years next after such offense shall have been committed. The main purpose of the statute of limitations is to keep defendants from having to defend themselves from charges that occurred so far into the past, that it makes it impossible to properly defend oneself. In many of these cases, evidence may no longer be available, making it harder to defend oneself and prove one's innocence. It would violate the defendant's right to receive due process under the law and the right to receive a fair trial if a prosecution was to take place under those conditions. The argument that the statute of limitations has run is a defense against a criminal charge, yet if it is not presented before a trial begins, the defendant likely has waived their right to use this as a defense. In order to successfully use the statute of limitations defense, it is necessary to show that the criminal complaint or indictment was filed after the 5-year period of the statute of limitations had run. Legal rules like the statute of limitation illustrate how many defenses and strategies experienced lawyers like Jennifer BONJEAN think about automatically after years of criminal defense practice. When the lawyers of BONJEAN's caliber listen to a story or read a narrative in a written report, they reflexively analyze the fact pattern in minute detail, spotting issues that can present possible avenues to challenge the prosecution. Practicing criminal defense law requires an intense and sustained commitment to protecting the rights of people accused of offenses who are being prosecuted by federal or state government authorities, and only after years of experience can an attorney effectively analyze every fact pattern and spot every issue. It is not surprising to find lawyers who thought they were competent but actually missed the expiration of a statute of limitation and allowed their clients to be imprisoned. Although victims of a civil or criminal offense may sometimes feel that they are denied justice by a statute of limitations that prohibits the prosecution of their offender, there are several common-sense reasons why such statutes exist. The main reason for creating statutes of limitations is to prevent potential defendants from being subject to unfair prosecution or other legal action. One concern that gives rise to statutes of limitations is the simple fact that after the passage of many years, relevant evidence may well have been lost. If so, it can unfairly hinder either the prosecution or the defense and lead to an unjust verdict. Of particular concern is relevant eyewitness testimony, especially if no formal statement was made by a witness near the time of the alleged offense. People's memories fade and become less reliable over time, and it is considered unreasonable to expect witnesses to be able to clearly recall details from an incident that may have occurred decades earlier. It is also believed that it is simply unjust to bring a claim against an alleged offender for an offense they committed in the distant past. Such an aspect of limiting prosecution is, of course, much more commonly applied to civil matters than to serious criminal offenses. Now, because the statute of limitations on the counts for which R. Kelly was convicted, namely the CPN inducement counts, expired no later than 2009, they were time-barred. R. Kelly, through his lead attorney BONJEAN, moved pre-trial to dismiss his indictment on statute of limitations grounds, but district court unfortunately denied his pre-trial motion. The court extended the 5-year limitations period for the conduct alleged in counts 1 through 3 and 9 of the superseding indictment until September 2009, when Jane reached her 25th birthday. The statute of limitations for count 10 was extended until 2005 when Nia turned 25 years old, and the statute of limitations for count 12 was extended until October 2009 when Pauline turned 25 years old. R. Kelly was not charged until more than a decade after the expiration of the statute of limitations under the applicable law at the time of the alleged conduct. Unless subsequent amendments to Section 3283 apply retroactively in this case, R. Kelly's convictions must be vacated and dismissed as time-barred. In 2003, Congress amended the statute extending the statute of limitations through the life of a minor, but the same Congress did not express an intent for the 2003 amendment to apply retroactively. Consistent with the well-established presumption against retroactive legislation, the 2003 amendment is inapplicable to the charged conduct, as is any subsequent amendments to Section 3283. Defense attorneys for the R&B King R. Kelly are appealing his CP and enticement convictions, weeks after a federal judge in Chicago sentenced him to 1 additional year in prison on top of his previous 30-year sentence. R. Kelly's attorney Jennifer BONJEAN filed her notice with the 7th Circuit Court of Appeals. That move was not a surprise, as BONJEAN had since the end of the trial stated her intent to appeal R. Kelly's convictions on 3 CP and the 3 enticement charges. Jennifer BONJEAN's comments had come shortly after United States District Judge Harry Leinenweber issued her R. Kelly a 20-year sentence on those convictions. But 19 of those years would be served concurrently with a separate 30-year sentence R. Kelly received in his previous racketeering and trafficking trial in New York. This means that if nothing was to change, R. Kelly will have to serve an additional year in prison stemming from his Chicago case. Prosecutors had asked Leinenweber to sentence R. Kelly to an additional 25 years in prison on top of that New York sentence, while BONJEAN sought an 11-year concurrent sentence. R. Kelly, through his lead attorney Jennifer BONJEAN, is definitely seeking to have the appeals court reverse his convictions or order for a new trial. We are sure that attorney Jennifer BONJEAN has already highlighted a lot of flaws, misinterpretations of the law, and issues to do with injustice in the appeal brief. With such an articulate and experienced attorney as BONJEAN, we are very optimistic that with or without an oral argument, the appeal process will expose the loopholes that the lower court left in R. Kelly's trial. For the rest of us who support and wish R. Kelly to regain his deserved freedom can follow the appeal process, keenly optimistic that he by the end of the appeal process will be a free man. Thank you for watching today's video, brought to you by SOS Media. If you haven't subscribed to our channel yet, please subscribe, and hit the bell icon so you never miss any of our videos. Also remember to leave your comment about today's topic in the comment section below. Thank you for watching today's video brought to you by SOS Media. If you haven't subscribed to our channel yet, please subscribe, and hit the bell icon so you never miss any of our videos. Also remember to leave your comment about today's topic in the comment section below.